Now, let me deal with the questions that I have identified. First, the reasons for issuing the stern warning rather than the prosecution, the sufficiency of the DPA and the SOF. Decisions on charging are made by the public prosecutor. In deciding whether to charge, the PP has to consider whether he has the necessary evidence to prove that those individuals were involved in certain conduct and possessed a certain mental state to establish the offences. In this case, as CPIB explained in its media release, there are evidentiary difficulties in doing so. Simply put, there is a lack of sufficient evidence, either documentary or through witnesses, which would establish any criminal charge beyond a reasonable doubt against a specific individual. AGC has made a number of mutual legal assistance requests over 5 years. To date, the findings from these requests are insufficient for prosecution, as I will elaborate later. Given this reality, I would like to know if any member thinks that nevertheless, even without sufficient evidence, the PP should have proceeded to bring charges against individuals who deny the allegations against them. If so, please let me know, and the basis on which you say so. Now, does the fact that KOM had entered into the DPA make a difference in this matter? And would the DPA be enough to at least commence prosecution against the specific individuals in question? The answer is no. The DPA and related documents were entered into between KOM, the US Department of Justice, and the US Attorney's Office. KOM USA, a wholly subsidiary of KOM, also entered into a plea bargain agreement with the US authorities. No individuals were parties to these documents. While the documents make reference to the actions of certain individuals, I have been advised that those references on their own are insufficient to establish any offences beyond reasonable doubt without witnesses testifying in Singapore about the context surrounding those actions and the intention behind them. In short, the agencies do not have sufficient evidence that would show beyond reasonable doubt that any of the 6 individuals were guilty of an offence. CPIB conducted an in-depth investigation within Singapore, within the scope of its legal powers. However, as I said earlier, the difficulty with this case is that several potentially key witnesses are not in Singapore, and CPIB has not been able to secure their cooperation or agreement to testify in Singapore. With the initial assistance of the Brazilian authorities, CPIB made 2 fact-finding trips to Brazil in May and August 2019. AGC and CPIB sent 3 mutual legal assistance or MLA requests to Brazil to secure evidence that was needed. AGC and CPIB also sent an MLA request to another relevant foreign authority to interview other potential material witnesses. The contents and outcome of these MLA requests are confidential, but I can inform the House that they have either not yielded evidence that could be used to secure conviction before our courts, or the responses have not been helpful in advancing the case. There is one foreign witness who gave evidence in other proceedings which could have been relevant in establishing the offences in Singapore. However, that foreign witness is not willing to voluntarily give evidence in Singapore. Neither AGC nor CPIB can compel him to do so. Some members may ask whether any prosecution could be advanced arising out of the fact that a particular individual had entered into a plea bargain in another jurisdiction in relation to his involvement in the KOM bribery. When this individual was investigated by CPIB on his return to Singapore, he denied knowing that commissions paid to the agent in Brazil were paid out as bribes. He did not, during CPIB's investigations, implicate himself or any others in conspiring to pay bribes. Even if the PP applies to a Singapore court to admit the plea agreement, the agreement did not identify any specific individuals and was made in the context of a plea bargain. and will be given limited weight without further supporting evidence and in the face of potentially conflicting oral testimony. CPIB has conducted as thorough an investigation as it could with the information and powers that it possessed. However, given the cross-border nature of this case and absence of key witnesses, CPIB's investigations could not overcome the evidential difficulties for the purposes of prosecution in a Singapore court. As such, stern warnings were issued. If subsequently new and compelling facts come to light, it remains open for the PP to re-evaluate the decision in the light of the evolving legal and factual matrix.